In a report by UNICEF, some 100,000 children in Malaysia could be victims of online sexual exploitation and abuse. Andrea Varrella from ECPAT International, an anti-child trafficking and exploitation group, says Malaysia can do a lot more to strengthen legislation and close the legal gap in children's protection from sexual abuse online.
What we see from disrupting harm as one of the ways to disrupt harm and to address this issue is actually to provide additional financial resources to the ordinary courts so that they all have the same level of child-friendly measures in a systematic way, but also to increase the number of special courts for child sexual offenses. And this also goes back to the fact that these special courts on child sexual offenses come from a very important piece of legislation in the Malaysian context, which is the Sexual Offences Against Children Act from 2017. What we found, though, in our research is that there are not many prosecution of offenders under this under this Sexual Offences Against Children Act. Because in many cases, offenders are actually trialed under other pieces of legislation, other provision, including the provision of the Penal Code against homosexuality. This means that then there are more difficulties for the children to have their case heard in the special courts because it's not necessarily automatically considered to be a case of online child sexual exploitation and abuse.
She urges more awareness of the Sexual Offences Against Children Act 2017, alongside education and training for legal practitioners. Andrea also highlighted provisions in the Act to be improved so that efforts to combat online child sexual abuse can be carried out more effectively.
The Sexual Offences Against Children Act criminalizes very comprehensively child sexual abuse material. So child sexual abuse material is any type of material which includes child sexual abuse. And the Sexual Offences Act Against Children in Malaysia criminalizes incredibly comprehensively, I want to say. So it includes visual material, but also audio material, written material, and so on. It also includes some provision that refer to another phenomenon, which is called, we call it online grooming. And in Malaysia is referred to as sexual communication with a child. So it's not exactly the same, but online grooming can be charged under this act. What we saw that was somehow missing in this act when it comes to the criminalization of OXEA, of online child sexual exploitation and abuse, is first around the concept of live streaming of child sexual abuse. So this is child sexual abuse which is live streamed online through a computer or another device. And so there is no storage. Is never stored on a file, on an image, or on a video, or so on. And what we say from Disrupting Harm is that either there needs to be a distinct provision criminalizing live streaming of child sexual abuse, or the provision on child sexual abuse material, which currently in Malaysia are used also in this case, need to say explicitly that this also applies when the material and the child sexual abuse is not actually stored anywhere. There is no material.